All right. We hope you all had a very wonderful lunch. Did you?
Yes.
Great. Thank you. Um, Thanks to our colleagues for arranging the wonderful dialogues during lunch session and a terrific session before our lunch for moving forward. Now, I have a special announcement to make. I am on the board for an organization called Weinstein International Foundation, where Judge Weinstein has given a lot of money and collected other people for similar thoughts to try to engage people around the world in mediation and spread the word the best we can. Accordingly, I had a pleasure of inviting some of the JAMS fellows from around the world to come to this conference, and to our good luck and fortune, many of them are here today. Can I invite you all to please stand? All the JAMS fellows, Weinstein International fellows. And now please remain standing for a second. Now these are individuals who are not just teaching, but also practicing mediation, practicing arbitration on a daily basis. I will have them say their name, the country they are from, and one word about their bio, okay? So let's quickly, please start, yes.
I'm from Brazil. I do mediation. I practice for 20 years. I teach for 20 years.
Thank you. Gabriela, welcome from Brazil.
I'm from Argentina, but from the north of Argentina, that's a bit different. I'm from Buenos Aires, and thank you very much.
Thank you for being here. Yes.
Hi, I'm Gonzalez. I'm from Fordham, I'm a consultant to the judicial legal, working on court-annexed mediation.
Thank you. Welcome.
I was born and raised in Spain, but since 1995 I have been living in Mexico, holding a position as faculty in the Legal Research Institute National Autonomy University of Mexico. I am international family mediator.
Thank you. Welcome.
Hi, I'm Elaine and go by Elaine because my last name is really hard. And I'm from Cyprus in Greece. I'm here in training as well, and I'm really glad to be here.
Welcome.
Hello, my name is Ambar Asmanov. I'm from Uzbekistan. I'm based currently in Sacramento and doing my JSD in International Law Resources Law. And my topic is about mediating international law disputes. So, and I was blessed to become a fellow of the
Wonderful. Welcome, sir. We have Jimena. Is she here? She's outside. Okay, we'll have her again. Thank you all. Next session. Art Hinshaw.
Thank you, everybody. We have the, what should I call it? The somebody has to do it task, which is to be a part, the challenge is to do a program right after lunch. So we were the unlucky ones, lucky ones. And we're going to be talking about engaging the real world. So those of you who were talking about the real world and are here to hear about the real world, this program is for you. And just a couple of quick items. I'm not going to go down through my esteemed colleagues here. Why? Because we're going to talk in just a moment. You can read our bios elsewhere. Also, all of you should have a card at your table. What we're going to do, we figured that some of you will start napping halfway through. So we thought we would ask you to, if you have a question or something like that, we're going to do a short Q&A during the middle of our program. So if you have a question, write it down on this card. And about halfway through the first half of our panel or so, we're going to have some students going through. So just pass it to this row, or that row. And somebody will come by and pick it up, and they will give it to me, and you won't even notice, and then I'll make sure that all the questions are appropriate. Well, you never know. So, engaging the real world classroom teaching and scholarship. So we're going to do the Q&A in the middle. At the end, we're going to have a little bit of conclusion so that we can get some good thoughts from these thought leaders. So I've always maintained that we are probably the best group in law schools to sort of engage the real world as it is. But, when the bar is this high, it's not very far to jump. And so there's some room there, and we're here to talk about that. So, while we can improve, we could look at aspirational places like where? Business schools. What do they care about? They care about developing problem sets. How many of you get tenure, of you who are academics, get tenure for creating problem sets? I see a lot of hands not going up. So we understand that. And so then the question becomes really, why is there this disconnect, if there is one, about what we do in the classroom? We've heard a little bit about this this morning, and what happens in the real world, and why is that? And so we've got some questions that I'm going to ask our panelists here. And basically, Donna, I'm going to start with you. Hello, Donna Shostowski. What are the key differences between the techniques that we see in the real world and what we teach in the classroom, and why is there this disconnect?
That's a great question, Art. Thank you.
Not scripted. Not scripted
surprised. So based on my experience, I think we spend a lot of time teaching our students how to use integrative bargaining techniques useful for negotiation and mediation, and then when they go out in the real world, they don't see that being reinforced in a lot of the workplaces that they operate in. So I also think that we focus a lot of our teaching on litigation, and then when you do go out in the real world, you see a lot more reinforcement, relatively speaking, of integrative bargaining techniques in transactional work, where people get rewarded more institutionally for those kinds of creative deals that we try to teach people how to do even in the litigation context. So we teach students integrated bargaining. They go out to be junior litigators. They go to workplaces where they're told, oh, that doesn't really work in practice, and then they don't get reinforced in terms of what we teach them, which is a real problem. And I think part of the reason for this is that so many people more senior to them in the workforce, who are their mentors and who reward them institutionally, did not learn about these strategies when they themselves were in law school. And I think they go ahead and continue the habits they've always had, and that's what people are kind of taught they should do, even despite our best efforts to teach them otherwise. So that's in terms of negotiation and mediation. Just a brief word about arbitration. I think it's a very rare school that teaches people actually how to be an advocate in arbitration. Raise your hands here if you have a class that offers that. It's not common, right? I mean, it's just not common. Usually we're teaching people about the case law, FAA, Supreme Court, and the like, not a skills course in arbitration. So I think that's part of the problem too. We don't teach people how to be advocates in that context at all.
All right, Dwight, same question.
So there is a large chasm between, they're both real worlds, the world of practice and the world of academia. And what struck me back a month ago, I was teaching would-be mediators in Kentucky, and I was talking about the difficulty of the chasm and having 1 foot here, 1 foot. They didn't realize it was a chasm. They don't see our side. They only see their side. There is no chasm. You'd say, well, I'm not going to make any comments about any one state, but I would note that if we take the programs, like the program starting on Thursday, and you ask, it's for practitioners, how many of us are teaching in that program? The answer would be, aside from some Pepperdine faculty who are somewhat matched with practitioners, nobody. There used to be people, but they don't draw very well because practitioners want to talk to people who they think know what they do and can help them solve their problems. And they don't think they're to be found, I guess, in law schools. Same thing happened at a conference in Canada. 2 of us, law professors, were put on the end of the second day. The headliners were experimental psychologists who could talk about how people actually make decisions and the empirical data on that. Now you say, well, that's their problem. But I would note that after, 20 people who are going to be at this table today, there is 1 practitioner. And that tells us something. I don't think either side is listening very hard to the other side. And that creates real disparities in terms of practice. So let me challenge you and bring in a bit of the real world. The way I'm going to do it is this. I've filmed lawyers from around the country and other parts of the world. I'm going to show you 2 lawyers from the firm of Wilmer Hale in Boston, the head of the real estate department and the head of the IP department. They're negotiating a version of Sally Soprano, in which the guy in the white shirt is willing basically to produce the speaker for nothing as long as they get help with their career, and the other guy's willing to pay up to $20,000. The whole thing lasted 45 minutes. I didn't script it. I can't show you 45 minutes. This morning, I cut it down to 70 seconds. That may be a little tight, but go to the video.
Josh, thank you very much for coming in today.
Thanks for having me here today. I think that, Patrick is interested in hearing more about what would be involved.
Curious about how much of this he does. I know he did it 20 years ago when I first came across him. Is that what he does today? Is that what he's doing in the States? Or?
Patrick does a number of things, curious as to your thoughts, but lead to more of these, right? I mean, I think it would be great if this was just the beginning. Had you thought about that?
So yes, our hope is to grow it, and key to that is to have a good first year. If he's looking to use this as a platform to see the companies, it's a really good platform.
Well, that all sounds good. So what kind of terms are we talking about for Patrick?
Patricia, who's well known, we were going to pay her $10,000, and she had to come in from San Francisco, so there's some costs to that.
Well, I'll certainly have to run it by Patrick. I think the question is that, given what needs to be done between now and then, the short time frame, I mean, I know you're in a difficult position, and I'm sorry to hear that. I think Patrick, would like to be able to help out. I guess the question is, can you do better than that?
This is our first season, and quality of the programming is more important to me than whether it's 5,000 or 10,000 or 15,000.
All right, that's 70 seconds. So what I see is a cooperative problem solver negotiating with one of Charlie Craver's manipulative problem solvers. And you can watch the whole 15 minutes. I've excerpted, and you'll see what happens. They have some non-monetary terms, but basically, the challenge I see presented by videos, and this is reality that I see, is A, how do we teach people to do what the guy in the shirt is doing? And we do that pretty well. How do we teach people to do what the guy in the white shirt is doing? Because clients are going to want that. How do we teach the guy in the suit to deal with the guy in the white shirt so he doesn't end up having his lunch eaten, okay? How do we teach two white shirts who are in a collision in mediation? And finally, I'll say, I was once asked to teach for 3 hours at a large law firm, and the equity partner said to me, take 1 hour and focus on the most important negotiation if you ever want to be an equity partner in this firm, the negotiation we do with our clients. And that's going on behind there. I've now said client. I believe that's the 4th time this program, that word's been used. I think if practitioners were talking, you'd be hearing it more often because they're driven by that. So anyway, I think there are challenges in negotiation. I'll just say in mediation, I think we have one model. The problem is it doesn't fit all. I think we do a better job if instead of trying to convince them for the nth time that opening sessions are a good thing, we talked about workarounds. If they won't do an opening session, how can we deliver some of the benefits of an opening session? And I think there are some answers to that. I think interests are helpful, but as you'll see from an article coming out, I think loss is almost ever present when people settle. And we need to be, in some sense, conducting grief counselors in a way. Some of my worst mistakes in mediation have been when I've tried to save marriages that couldn't be saved, commercial marriages. So that's a problem. And of course, the problem of, I think, the clients are at the root of a lot of this. The folks who watch NFL football on Sundays and then come in and give instructions to their lawyers about how to negotiate. So that's my thoughts.
All right, some back chair, I'm going to mix metaphors, back chair quarterbacks, armchair quarterbacks, whatever you want to call it, backseat driving, that too. Just a reminder, you have these cards. If you have a question, please fill one out. We're going to have students start going around in the next couple minutes. To pick these up, remember to send them to the aisle, and we'll get to them midway through. So, Sarah Cole, another shocking question. I hope that you're ready for it.
Yeah.
Does our teaching impact or reflect the real world, and should it?
So thanks, Art, for that interesting question. And thank you to Pepperdine for inviting us all here. This is a very interesting and thought-provoking symposium, and I look forward to participating in it and to listening to others. I take a slightly different position, I think, about this than Dwight does, which is I think we do incorporate the real world into the classroom, and I think that in dispute resolution courses, as Art said at the beginning, we do it much better than most of our colleagues in the rest of the curriculum. And I think we have to be mindful of the fact that we typically have these students for the last 2 years of law school, and that perhaps they are going to take 2 classes in sort of skills-related activities, maybe 3. Our certificate students probably take 5 or 6, and there's about 20 of them. So it's not realistic to think we can teach them everything about the real world. And I don't think the law school experience is really intended to accomplish those goals. It's more to introduce them to the skills that they will no doubt be honing in whatever forum they end up in, whether it's a big law firm and they're doing commercial mediations, or whether they are representing clients who have small claims. And so I think it's important to think about why you're teaching the students the particular things you are teaching them, while also at least exposing them to some of the controversies in the field, like should we require joint sessions when the lawyers say there's no point to a joint session, it's very positional and I refuse to participate in it. And I think I found a little quote from Martha Minow while she was still dean at Harvard, who said, "At law school, we daily acknowledge the differences between theory and practice and between thinking and doing, while also working constantly to bridge the two." And I feel like that's what we generally try to do in our dispute resolution courses, at least I think that's what I try to do and my colleagues at Moritz do, which is to think about these important policy issues, legal issues, theory questions, access to justice issues. Is confidentiality in mediation important? Should we have arbitration at all if it's mandatory or forced? All of these really important questions that would be part of any law school curriculum or any law school class focusing on legal issues and theory issues. But then we have this unbelievable and unparalleled opportunity to bring in what actually happens in the real world. And the way we're able to do that most effectively at Ohio State is through the mediation clinic, where we teach our students how to mediate. We spend about 16 hours doing that before they go down to various venues to mediate the cases themselves. We bring in outside mediators to help coach them through the process of learning a little bit about how to mediate. Of course, we don't think we've taught them how to be mediators at the end of 16 hours. And so we supervise them down at Small Claims Court or in the Prosecutor's Resource Unit as they try to deal with unrepresented parties in mediation. And absolutely, we teach them a facilitative model. Number one, because I wouldn't want a second-year law student evaluating my legal claim, but also because these parties have the moments that those in commercial disputes typically don't. They sometimes do develop an understanding of the other side's point of view by listening to the other person. They have that kumbaya moment where, although we won't let them leave together, they could, we think, be leaving together. And I was telling Nancy Welsh out in the hall, I watched some students mediate a case this year where one party showed up an hour and a half late to the mediation, but the mediators encouraged the other party to stay there, and she did. And he came in, didn't want to, admit he'd done anything wrong until his friend said, when you didn't return that money to me, I lost my apartment and I had to move into a homeless shelter, and my bed was urinated on by other people in the homeless shelter. I mean, the other side was like, oh my God, I had no idea what I'd done, and was at that point quite willing to pay the money, and they were no longer, at least at that moment, angry with each other. I'm not 100% sure that the party who developed that understanding would change his sort of jaded ways going forward, but at least at that moment, they did develop that understanding of each other. And I'd hate to see us not teach joint sessions and facilitative mediation because lawyers out there don't always desire it. I think it's a lot about choosing the right type of mediation for the forum in which you're mediating. And that means if you're a mediator who does lots of different kinds of mediation, you have to be able to adjust and adapt to the situation you're in. When I've done commercial mediations, I have routinely been told by lawyers that they do not want a joint session. They feel like it entrenches the parties and angers them. And Dwight was talking a little bit earlier about workarounds, and I thought he had a great idea, which is, okay, they don't want a joint session at the beginning. Let's figure out a way to work around that. 4 hours into the mediation, they're calmer, they're starting to work more productively, they have faith in you as a mediator. At that point, maybe they'll be able to get together and have some kind of useful conversation. And I don't know about the rest of you, but when I'm doing commercial mediation, half the time I'm very confused as to what the underlying deal is, and they're showing me X number of documents, and they're giving me different points of view about what those documents mean, and I think, wow, I wish I could get these people together, because they would be much better at this point where we're just trying to negotiate something, to be able to say, oh, well, this is what I meant about this, and these numbers mean this, instead of relying on me, the terrible, what is it called, telephone, where I go in the room, they say, well, what do you mean by X? And I'm thinking, I have no idea what I meant by X, because that was just the word the other person used. So I don't know how much time I've used up on that, but that's at least
Okay. John, did you have something that you wanted to say about this?
I wanted to say a couple things. First, I wanted to pick up on Dwight's point about not talking about clients. I think in dispute resolution classes, we probably talk about clients more than in lots of other ones where clients are basically just cardboard characters who fill in a role to illustrate the points. So I think we do focus on clients more, but I think there's room for more. We tend, particularly talking about these processes like mediation and arbitration, focus just on the tail end. From the client's perspective, it starts way before that, and it would be helpful for us, and particularly teaching in law schools, those of us who do, to focus on the interviewing and counseling and beginning from the very beginning of the case, which is what the clients focus on, and also focusing on the lawyer's perspective on it. The other thing I guess I wanted to, so not just the tail end, but the whole case, which is why I have encouraged people to do these multi-stage simulations so that students will experience it not just from the tail end, but from the beginning. The other thing is there's been a lot of discussion so far about teaching the right way to do it, and more of the theoretical stuff that we like to teach in terms of interest-based negotiation and facilitative mediation, and whether we should have joint sessions or not, or all these techniques about sort of what the right way is. And another way of thinking about it, which I would recommend, is to think about helping people, clients and lawyers, make decisions. So rather than having us say, well, you should be using this procedure or that procedure, talk with them about what it is that they're trying to do, and think about how you can be most helpful, or how students can be most helpful in accomplishing whatever it is they're going to want to do. Earlier, Jean was talking about how people come in with the motives and the interests that they have, and I think it's hard for us to expect that we're going to do a personality change on the parties when they're going to come in, or their client or our students will. And so in some ways we need to be thinking about, and our students should be thinking about, dealing with the clients and the lawyers as they are, sort of taking them as they come.
Okay, perfect timing, because your time is up. All right, so yeah, I was about to throw something your way. So I've got some questions here, some really good ones. I really like them. Thank you so much for doing this. First question to whoever wants to answer it. Do you think that law school professors, not adjuncts, should have more practitioner experience?
Ooh.
Okay,
because
Sarah.
that was actually something I was going to comment on, and I couldn't count everybody who said that they taught in law school but also engaged in the practice of mediation or arbitration. But I thought it was actually quite a few people. And I think there was a time when we thought law school professors couldn't possibly teach skills because they didn't have any of them. And I purposely, when I came to Ohio State, started developing my mediation and arbitration skills, which was not something I'd focused on except having participated in them a little bit in practice. And I think more and more law school professors, especially in our fields, are trying to get that practical experience so that they can bridge the gap between the real world and the law school classroom. And I think it's particularly possible for law school professors who teach in this area because we're actually not unattractive as neutrals. In fact, maybe we're attractive because we're not associated with one side of the fence or another, and people tend to perceive us as neutral. So I think there's absolutely a value to bringing practitioners into the classroom or having practitioners teach. But I've also had more of a mixed result from that, where I might bring someone in and they spend an hour talking about their background and 5 minutes, and then I'll stop.
Excellent,
Yes.
excellent. I'm going to change this question just a little bit. Why don't professors feel a responsibility to empathize with lawyers and advocates who don't want a joint session?
Good question.
I was just going to say that I think there's something to be said for trying to empathize with lawyers generally. They are the intermediary between some very difficult people, and I often think they have a harder job than I do because they deal directly. I think we need to empathize, and I've heard some good reasons for not holding joint sessions, or at least not holding a joint session at the outset, or defining it, or deciding who's going to be in the joint session, et cetera. I don't think we deal with that in the one-size-fits-all model.
Sarah, did you want to add to that?
Just one sentence. As a practical matter, mediators want to be hired again, and if the two parties or neither side wants a joint session, it's pretty hard to have the fortitude to say we're having one anyway.
Okay, I'm going to take moderator's
One
prerogative.
sentence?
Oh, nope, moderator's prerogative. So I just have to say, I was doing some mediations, and I got everybody together to just sit, just to say, like, this is what we're going to do today. One party saw the other party in, healed, whoosh, turned around, walked out. And I went down and caught them down the hall. I said, what's wrong? And they said, oh, that's not my room. That's their room. And I had to bring this person back so I could just say, this is what we're going to do today. I only want to explain it one time. All right, it was really hard to make that happen. All right, next question. Sorry, Dwight. What common pedagogical practices should we abandon? What should we abandon?
Teaching that there's the right way.
You mean we should talk about process flexibility?
Particularly those of us who believe in facilitative mediation.
Wow. Any other takers? Is that too big of a question for us?
It's a hard question. It's a hard one to.
I got
think
an answer.
I was struck 2 weeks ago, I rather impromptu filmed French mediators who actually are the leading mediators in France and who sit as judges of the ICC competition. What they showed me as mediation, as they recommended, had absolutely no relationship to what I saw as a mediator at the ICC. I think there is a big disjunction, and maybe we need to rename our competitions as interest-based bargaining competitions. As that, they could be useful.
All right, one last question here, and I'm going to direct it to the panel. So what advice do we give to our students when they have to negotiate with President Trump?
I believe there's an entire issue of Negotiation Journal dedicated to that.
And so besides telling them to read, what pithy quotes do you have for the video? Anyone?
Try to empathize. It's a rough crowd.
Yeah.
Trump has said what he finds helpful. Develop your BATNA and stick to it.
Ask him what his interests are.
His interests, and stay firm on your interests, right? You don't give up your interests just because somebody isn't doing what you want them to do. All right, so we're going to go into the next portion of our program and our next question with Jen here on my left. Jen, does our scholarship and teaching impact the real world, really?
Oh, well, that's a great question, and I'm sure. No, and I mean that it's a little bit different than the one I had prepared to answer.
Thank you.
I bet that there are many people who have published law review articles or journal articles or blog posts in this room who have received a call from a lawyer or a policymaker or a client that said, I heard about that article that you had written. Would you be willing to talk with me about it? And I will say immodestly, in my limited way, I've had a couple of those calls, and they're really scary as a professor, because you start to realize, wow, somebody may actually take me up on this, and am I ready for, to follow through on that? So I think they can impact the world. And now I'm going to give the answer I had prepared to give. Part of the reason it's difficult for them to have that impact is that there is this disconnect in what we teach and in what we write about, not only with respect to the skills that we want to teach our students or the concepts between distributive versus integrative, competitive versus cooperative, interest versus positions. I think there's a related disconnect in some of our assumptions about people. And by people, I mean, clients, disputants, advocates, and even judges. And we make these assumptions about what their desires and capacities are, or what they experience their desires and capacities to be. And I'm referring here to two things. One, I think we build some of our ideas in this field on a premise about people's capacity to sit with and directly confront conflict. And that's what sometimes leads to this inability to think they wouldn't want a joint session or they couldn't tolerate a joint session. And so we have to be very, very careful about that. And by the way, I think that applies not only to parties and their advocates, but when we've done trainings for judges in mediation, I've been shocked by how low the tolerance is among judges, especially among judges, to sit with conflict and parties in the same room. That it's really interesting to me. And then the second assumption that is problematic, I think, is that we build some of these things on foundational beliefs about a desire for autonomy and self-determination. And it's kind of scary for me to hear myself saying that, but I do think that there is, that's what leads to this disconnect between our preference for mediation and then what we see in the real world, people wanting much more arbitration and directive mediation and, make the decision for me. I never miss an opportunity to give a shout out to Ellen Waldman and her wonderful piece about the role of norms in mediation. And I think it's an old piece that came out a long time ago, but it gives us a great chance to think about how sometimes people really don't want as much autonomy necessarily or self-determination. And I just want to make a last point before my time is up, kind of referring back to some of the macro points that people were making this morning. The thing that I find really most concerning about our disconnect with respect to autonomy and self-determination and the ability to sit with conflict and to be in conflict is that what it tells us about really fundamental issues of civil discourse and democratic values. And if I can put on my dean hat and now interim provost hat for just a second, and I swear Chris Guthrie and I did not plan this ahead of time, but I think the way forward for our field is to hold ourselves out as the experts in civil discourse and in thinking about democratic values. That is, how do you foster in people some willingness to exercise their own self-determination and autonomy, and leadership development is a great way to do it.
Does anybody have any follow-up comments on scholarship and teaching reflecting the real world?
I wanted to comment on the sitting with conflict part of what Jennifer just said. And I guess one of the things I think is a huge value of having students learn how to be mediators while they're in law school is that they typically are mediating for unrepresented parties, and they typically try to keep them in joint session because we've told them to do so. And as a result, they sit with this conflict and try to implement the skills we've tried to teach them to help the parties overcome that conflict. And as I was mentioning before, that does happen. And it's interesting to me that unrepresented parties are sometimes, I guess, better able to sit with their conflict than others, and maybe because they also see this as a place they kind of have to stay, even though we tell them that it's voluntary, but they're in a court, and so they're not really sure that's true, or I hope that's not the way they feel, but they certainly do sit there with the conflict in a way that represented parties are shielded by their lawyers from having to do. So.
And it may be because that's why they have lawyers to shield them from that. Dwight.
Well, I'll comment that I never could understand what the leadership training and interest of the deans in leadership was about until I actually heard Chris, and I thought, wow, okay, now I understand it. And I think the ability to sit with conflict, I think back to the roles I play other than a mediator, whether leading my church or in corporate boards or whatever, and that's a big part of what we can do. Yeah. We're sort of like surgeons get used to blood, we get used to conflict. It just doesn't bother us anymore.
I think that I agree with that. We get used to it because we've had to do it. Donna, do you have something to
Yeah, I
add?
was just going to say, but back to the point about autonomy, I think one of the things we could do better in terms of talking to our students about the real world is that sometimes people talk about clients as though they're really static over time, but really sometimes what they appreciate about different options is very different at the beginning of their case versus at the end of their case. So, I mean, there is some interesting research by Tom Tyler and his colleagues suggesting that people value things like autonomy more after they've experienced the procedure as opposed to ex ante. So that's something that I think we could tease apart for our students a little better.
I've just had 2 cases, now that in the past year, I don't get a lot of hugs at the end of mediations, but I've had 2 cases where there has not been an opening session and they've hugged at the end.
Nice.
It's amazing. It can happen.
We call those victories. Yeah, John.
2 quick things. One is in terms of the went in and out of my head. In terms of opportunities to do scholarship, there are going to be 2 sessions following this breakout, 2 breakout sessions. And I want to suggest that there are opportunities for those of you who are interested in doing scholarship to do that in terms of interviewing people like mediators and lawyers and maybe even some clients. And that there, people think about empirical research as if you have to do a survey, which has some real challenges in doing it, but it's a lot easier to do some qualitative research, which I want to encourage you to do, to think about, which is actually easy and really fun in terms of actually having satisfying. I've done a lot of these interviews, and I've had some lawyers at the beginning would say, "Oh, I only have 15 minutes," and then an hour and 50 minutes later, I have to pull back and saying, "I know you're too busy to go on now." They've really thanked me, so that's an opportunity. So I'll stop there.
John, your comment brings a question to my mind that I didn't prepare beforehand. Integrating practitioners into our teaching scholarship. How should we do that?
Gosh, I've never thought of that question. Actually, I assumed that everybody in this room would know about the Stone Soup Project. But someone was telling me that maybe some of you don't know about the Stone Soup Project. So I'm not going to ask you to raise your hand to indicate whether you know about it or not. I'm just going to assume that there may be 1 or 2 of you who don't. So I'm going to take a minute to talk about that because that is directly related to your very prescient question.
You're very kind, John.
No, you were kind, Art. So anyway, the Stone Soup Project is something that at the University of Missouri, my colleague Raphael Helly and I have organized a couple of years ago. And without going into the whole detail, the idea was to learn more about what the heck is going on in practice. The original notion was to do this for scholarship and to develop a database of reports of actual negotiations, and we decided that just wasn't practical. We shifted gears to focus on using it for teaching purposes, and that has been wildly successful. And basically, we have encouraged faculty to assign things in their courses to have students do all sorts of things to find out about practice. Some of the faculty have had students do extensive interviews of lawyers or mediators and have the major paper in their course focus on it. Others have had just a tiny part of it. Some don't even write papers at all. And the response has been really surprising in terms of having students and faculty really enthusiastic about it. And I think also the people who've been interviewed, again, consistent with my experience, people really like to be asked about what they're doing. And it's a fascinating thing. We've gotten reports and we've got stuff on the website. Faculty have said, it's been really cool because it shows students that what we're teaching is going on in practice, and then sometimes they're going out and saying, "Oh my God, the stuff that we're teaching is very different from what's happening in the real world." So it's been a fabulous thing. There's a tremendous amount of flexibility. There's a website with all sorts of materials up there, including models of assignments and assessments. People have done this. It's been a fabulous experience, that part of it. We've suggested 3 other things, which shockingly there has not been any uptake that people have told me about. One, and I recommend all of these things, and hopefully maybe some of you will do it in your courses. One is a variation of having guest speakers, and I bet probably many of you who teach bring in guest speakers, and this would just be doing it a little more systematically like a focus group. So you may get a set of speakers, so you may have someone who does a facilitator and evaluative mediation, or a judge and a lawyer and a mediator, or I did some with in a negotiation class with someone who did civil and criminal. So, and you have focused questions going into it, and maybe developing plans with students what those questions would be. So it's a variation on what I think a lot of people do. No one has told me they have done it, but I recommend it to you. A second thing that I thought was a fabulous idea, again, 0 people have told me they've done it. For you, I'll tell you. And that is to take advantage of the opportunity from competitions. I bet many of you have been judges at competitions, and you've had other judges who've been practitioners, and you've had somewhat different perspectives about the performances. And I've had the conversations with these other, with the practitioners, and that's been a fascinating thing for us. We didn't have a lot of time to talk about it. We didn't have a lot of time to talk about it with the particular students who are competing. And the thought was to have a general debriefing afterwards to talk about, invite all the students and invite, as many judges as, you want, and talk about what was going on in that the competition without identifying particular students or their performances. A terrific idea. The other thing that I have done, and we're actually institutionalizing in this conference, is to write blog posts about events, and not only that, but to elicit input. So I've done CLEs, and I bet a lot of people in this room have done CLEs, and in addition to sort of having questions and answers or questions from the group, part of it is you can plan ahead to say, okay, we have a set of respondents here, research subjects. I'm going to ask you some questions, and we're going to record it and elicit information from them. So use the CLE as a data gathering instrument, and then publishing it. So, I happen to be one of the bloggers on the Indisputably blog, along with Sarah and Andrea and some other characters, and that's one too. Art. Okay. And if you don't subscribe to Indisputably, shame on you. What's wrong with you? So you can post it there, or we will post it for you. So those are. Oh, and then one last thing. We need to have a common language. One of the blog posts that I wrote was talking about how important that is, and this came to me in part because of the fabulous report that Roselle Whistler, on behalf of the Committee on Mediation Research, did. And one of the recommendations was we need to have a more common understanding about different behaviors that people are doing. And this would have a lot of benefits, particularly in terms of talking with disputants and helping students understand what's going on, instead of these crazy words like facilitative and evaluative, which people think they know what it means, but nobody has the same understanding, and the disputants don't know what it means. So I would encourage us to make that a top priority.
Art, can I, into scholarship? Short articles.
Short articles.
Like, could you produce a 2,500 word version of your 25,000 word opus?
Okay, so
I could read that.
Listen. All right, Donna, scholarship, engaging the real world.
Yes, I think partnering with practitioners is so wonderful, very valuable, especially if your work relates to an area in which you've never practiced, or maybe you haven't practiced in a while, because sometimes you don't know what you don't know. And I've seen a lot of people in psychology, for example, who do psychology and law research but never bother to partner with a lawyer or get feedback even on their work from a lawyer, and they make all sorts of mistakes in terms of how they design their studies or using the terms completely incorrectly. I've done that myself. When I was a grad student, I did a study where I was trying to look at how people view negligence issues, and on the scale that I had my participants do a rating, we use guilty to not guilty. And my advisors didn't point out the error. It got published with the error. Anyway, so if I had only partnered with a real lawyer, I wouldn't have made that mistake. And this is before I went to law school. But the point is, you just don't know what you don't know. And I think some of the challenges, though, associated with working with the practitioners, they have different reward structures at work, right? So they maybe don't want to publish in the same journals. They don't have the same timeline that works for them. They don't have summers free of teaching where they can focus on their research and that sort of thing like we do. So I think that there's some real challenges associated with it, but the beauty that can come out of it is amazing.
Any other comments on scholarship and engaging the real world?
I have a comment. It kind of is like John's point about stone soup, but I published an article maybe 9 years ago about using mediation to resolve disputes that are framed as a clash between norms of religious liberty and LGBT equality, and used like 3 cases that were litigated in federal court. So mediation, as far as we know, was never even tried. But what I actually did was looked up the phone numbers of the parties who had been defending their religious liberty and tried to get on the phone with as many of them to talk to them and explain about mediation. How would that have felt for you? It's a weird kind of empiricism. It's a weird kind of interviewing to do, but it was so interesting. So I just recommend any time you're writing about something that actually was litigated. And I think we're scared to do it because we think, is this unethical in some way? But I think one can have a conversation without drawing out damaging information.
If I can just pick up on that, 2 things. One is people have this misconception that it's not empirical if you don't have numbers, if it's not quantitative, if you don't have a survey. That is wrong. Wrong. There are a lot of qualitative methods, including qualitative semi-structured interviews along the lines of what Jen was talking about, and having the concern about ethics is absolutely appropriate. If you are in a university, then you need to go through the institutional review board. Some people have had bad experiences, but it can be done. You can survive, and you can make sure that you comply with the important ethical responsibilities, which generally lead you to doing better research anyway. But it's a fabulous experience, and I encourage it highly.
All right, we're going to do concluding remarks, and then I have a couple more questions to go through. So, Sarah, give us 1 minute, please.
Oh, geez. All right. I guess what I would say is I think that when I was listening to Nancy Welsh earlier, a lot of what she said resonated with me, which is mediation and other forms of dispute resolution might not be what was originally envisioned, but we've come a long way, baby. And so I think that there's I have hope while also being apprehensive about the field. But I think it's important for us not to think that one size fits all. Or that what is happening, when we talk about the real world, I feel like what we end up talking about is what happens in big firm, big commercial mediation. And I think that's important because those lawyers are definitely going to be hiring mediators, and they'll probably pay the mediators more money than folks in family law or those who volunteer their time mediating at small claims court. But I think that we have to realize that law school is a place to give the students a key to unlock the door, and they can choose how to do that as they go forward in their careers. And so if we teach facilitated mediation, but we talk about other forms of processes that lawyers use, we're probably doing them a reasonable service, and they can explore down the road if they decide that mediation is a career they want to do different things. And I think at any rate, we're teaching them how to do a better job for their clients by giving them sort of both a combination of theory and practice along with some skills that help them apply those theories to practice.
All right, Donna.
So when I first learned how to swim when I was a kid, I learned how to do it perfectly, and now I doggy paddle. And I think that's kind of like our role is to teach our students, to the extent that we believe there are best practices in a certain area, to teach them what those best practices are, but then make them realize that in the real world there's going to be tweaks, and you kind of bring your own art to the practice and the science of law, and that way we don't lose credibility on the back end when they see that things are not done exactly as we hope they get done.
All right, Dwight.
One of the law review articles I always like citing to practitioners is Doug Yarn's about the role of dueling in the 19th century, which is actually, you think, was a very efficient way of dispute resolution in certain respects. But what he points out, and I probably get this wrong, Doug, is that it started out with them shooting each other, like Alexander Hamilton and all that. By the end of the century, they challenged each other to duels. Honor was satisfied. The seconds would get together, and only 1 in 5 did they ever exchange shots. The culture had changed. I see culture changing. It became, in the mid-1990s, in general counsels, you got the sense that suing the other side without talking was kind of bad form, at least when you were dealing with another big company. The Kentucky mediators, apart from what I said earlier, told me that the number of cases, civil cases filed in Kentucky has plummeted, period. And I've seen a decline in civil cases in Massachusetts. Less cases getting filed even as the population goes up and the GNP goes up. Things are changing. I'm doing a study because Massachusetts, having destroyed its court-connected mediation system, is a great place to study. What happens if you build it, but you don't compel anything? Will they come? 70% of the tort cases are getting mediated voluntarily and privately in the sample. Not so many contract cases, there are reasons for that. But the culture does change. The two cultures, in a way, are sort of moving toward each other.
John.
I think we often focus in dispute resolution on the role of neutrals, particularly mediators and arbitrators. And I think that lawyers are important dispute resolution professionals, sort of picking up on something that Nancy said in her comments this morning. And lawyers play a really important role, and for better and worse, and we should focus on that both for teaching and scholarship. So I would recommend that. I think it would be really useful for us to understand and teach more and learn more about unbundling, because I think that some of that is happening. And I also think that there's an awful lot of self-represented litigation going on, and I think it would be really important for us to understand what the heck is going on with why so many cases people aren't using lawyers, and how that process is going and what could be done to make it better. Technology may be helping to some extent. There may be other things, but those would be some things that I would recommend.
Jen.
Two things. I sort of think of law schools as a sort of a city, and then there's the real world around them, and there are neighborhoods that are kind of on the outer rim of the city, of our city, and they're like clinics, externships, people who teach by simulation, and ADR more generally. We should also be asking our colleagues who live in the middle of the city how much they're engaging with the real world. And I think that is really the way legal education is going. And maybe we set an example, and we can be a kind of a throughway for the real world to reach the real estate and the contract and the tort and, you know, the criminal law course as well. And then just the last thing I want to say is, I just to push back a little bit on what Dwight said, that practitioners don't look to the academy for guidance. I think that was somewhat, maybe I paraphrased. But in the almost, I think now more than 20 years of the Quinnipiac Yale dispute resolution workshop, it's been very cool to see how many practitioners will show up a lot of the time. And I think there is a hunger for that. And sometimes it's just that we're there to convene practitioners who can talk to each other, and we're providing a kind of, I don't know, vocabulary or structure for them to be sharing ideas with each other that they hadn't really realized they wanted to share. So I think we need to be thinking about that function that we as can play in the academy.
I have some more questions that are left over from earlier, and I think these are two questions that have been with us for a while. And when I mean by with us for a while, I don't mean in my hands for a while. I mean with us as a family. And the first one says, to what degree can we introduce a more quantitative or algorithmic or more systematized process into negotiation and mathematically deconstruct ADR processes? Any takers?
I want to call on Mikala Keith in the back there.
Okay, John, what's the answer?
Mikala and I, with one of her colleagues, are working on a book where we include some of the, where we include some of that, and that has been the source of some real controversy. What we've found is anecdotally, very few lawyers or mediators are very interested in doing that.
I would say that I would put up with them not being mathematical, although I was at once a failed math major, if they would adopt a systematic, careful, outline for preparing. That's something we teach, and I think that's 90% of the battle, really.
Sarah, do you have?
I was just agreeing with that.
Okay, you were leaning in like you were
yeah,
about to go at it. So, no, it's really interesting. That's a really interesting question because one of the things is we try to quantify so many things, and people can't quantify their feelings. They just say, "Yeah, I'll just 10,000," and they just want to get the deal done or something like that. So while we can help people get there, there's still that human aspect to it where people will just decide they want to be done or not. And we have to leave a little bit of room for that. But we can't let them get away with not preparing. I think if there's one thing we want as a field to do, editorial comment from Hinshaw, is we want to teach people to prepare to negotiate at the very least. If they walk away from our classes doing that, it's a win. Yes.
And I guess what I would say is what Dwight said struck me because I've asked for pre-hearing mediation statements in a couple different mediations and been very specific in the questions that I'm asking, and then the lawyers just ignore it and give me basically an advocacy brief that they send to the other side, even though I've told them to just send it to me. And it's confidential.
Yeah.
So not only prepare, but actually do what the neutral has asked you to do if they've bothered to ask you to do something.
You mean follow directions?
Exactly.
Nice. All right. So
Crazy.
I'm gonna leave us with we have a hard stop at 2:00 because Suk Simran wants to make a couple of announcements. So I'm just going to leave us with some questions to ponder in the quiet of our study. And that is, how do we deal with academic assessment issues when we focus on real-world skills? What is it that we are grading? How do we do that? That's a session in and of itself. And another session is, what really is the objective of teaching? You see why I left this one for the end. All
And
right.
what is the meaning of life?
Exactly. All right. Come on down. Thank you so much, everyone.
What you may not know is Art Hinshaw has not only been helpful, amazingly helpful in this session, but he's also helping us in several other sessions. So thank you so much, Art, for moderating. Wonderful job. You can imagine I have a few announcements. Forgive me again, I'm here. One of them is to do with security. We have a broken glass here, so please be mindful of not walking on this side of the stage, right on these stairs. So please be mindful of that. We'll clear it hopefully soon. Second is with speakers. All the speakers are getting a Lincoln portrait, which is on in SR1, seminar room 1 towards my right, if you go out. And everyone in this auditorium also is getting a free portrait that we unveiled in the morning, specially drawn for you, and that is available in mailing tubes outside at the desk. So please pick it up, and if you're not coming tomorrow, then make sure you pick it up today. We may be able to mail it to you, but it's a hassle afterwards. Third announcement is that this is the last time we are all together today for this joint session. So after this session, we are having about 15-minute break outside, tea and coffee, and then we're dividing up into this auditorium. For those of you who are attending Learning Styles and Pedagogies, come back here. And the other half of you or so will attend in a classroom right behind the posters over there, appellate classroom, and that's research and scholarship panel. So please be mindful of that. Now, last announcement is that I lied, 2 announcements. One is there is an event tonight in Jonathan Club for those of you who have RSVP'd. Please notice and appreciate and be generous to us that we have reached the capacity, but if you have RSVP'd and you're not going to show up, let us know so we can give that space to somebody else. And if you want to show up and you have not RSVP'd, talk to us and let us see if we have a space available. But just that you know, we counted the people, and as it's a restricted capacity for us, so forgive us for that. But please talk to us. Please talk to Laurie Rushford, Chris in the back, myself, find us, any of us, and we will be happy to talk to you about that. Now, lastly, before we leave, we have student ambassadors here, Straus student ambassadors. Can you all stand up for a minute, please? Straus student ambassadors. Thank you all for all your help and your generous contributions and help. Folks, tea and coffee break, please. Thank you.
Like a picture of Lincoln or something?